I hope you're doing well. I hope you can see me. I see the light's not the best, but if you can at least hear me, then we can get through everything. Okay. So I've been asked to do a little talk on various compliance certificates, including solar and occupational safety and occupant certificates. So we're just going to go through them, and also how to declare a certificate invalid. You'll have sometimes in a transfer where the purchaser moves into the property and says, I've got an electrical compliance certificate from the seller, but there's wires hanging out the roof and lights not working. Please assist me. And we obviously got to know how to help them out and what to do and what not to do. So we're going to first go through the requirements for each of the certificates, and then I'm going to just quickly go into how we can declare them invalid if we need to declare them invalid. Okay, so the first one, if you look on page 5, is electrical compliance certificate. So basically, electrical compliance certificate is for the electrical wiring and outlets in a property. It does not include appliances. So if you've got an appliance that plugs into the wall, the electrical compliance certificate is valid up to the plug and not the actual appliance. So it's very important for you as a property petitioner not to think that, well, I've got an electrical compliance certificate, everything's valid. So obviously the stove, for example, the stove must be in a working order. And then you put on the stove, it either doesn't work or only one of the 4 rings work. And it causes a huge amount of problems. And then we have to go look at the Fustus clause regarding the stove, and there's a huge fight. So it must be explained to the purchaser that the electrical compliance certificate, or the COC, is up to the actual plug of any device, and doesn't include the appliance as well. So it's probably very important for you then to ask the seller things for, is your stove working? And just get confirmation that the stove is working and include that in your offer to purchase, because your COC is not going to cover that. Okay, so how do COCs work? When do we have to get one? The Act basically has come in and says that users must provide a certificate if there has been any changes or amendments to the system, or if there have been no changes for any certificate that is 2 years or less. So if you've done a transfer of a property and there was electrical compliance provided, and then the person doesn't like the house and wants to get out and sells it again within a period of 2 years, you can use that electrical compliance certificate. That COC is valid to be transferred, long as it's not over 2 years of age. In the circumstances where it's over 2 years, then you have to obtain a qualified electrician that is allowed to do electrical compliance certificates. You'll get different types of electricians. You have to ask them, are you a master electrician? Can you do COCs? And some can and some can't. So it's very important that you get the correct person. And not only that, I would always recommend that you don't get somebody who does the cheapest quote. So what often happens is that the seller goes and he doesn't want to spend a lot of money. He gets 3 quotes and gets the cheapest electrician to come into the property. They do a COC, and then it finds out there's all types of problems with the property because the guy didn't actually do his job correctly. And we'll go through the process of overturning that COC, but at the end of it, it gets overturned at a cost, and then the purchaser can sue the seller to come redo electrical compliance certificate, and the seller now has to pay again. The first guy's disappeared, and it's cost him a lot of money, or her a lot of money. So it's very, very important that we recommend to the sellers to only use qualified electricians, but also not fly by night, someone that's got a track record, so if there's a problem, they'll rather come back than not come back. So it's important for that. Just remember, a lot of property petitioners at the moment will have a list of electricians that they will refer to the seller. Make sure that you always let the seller know that you have a couple of panel of electricians and you cannot ever guarantee any work. It's just some of the electricians that you've worked with in the past that have provided good results. Don't say you must use this electrician or this electrician is the best. Utilize him, and I guarantee you, when things start going wrong, he's going to go and say, "Well, you referred this electrician to me, and it's your fault." And I've seen it happen countless times. So make sure that you just advise them, say that you've utilized them in the past and you have had good results, but they can use who they want. But here's some good names. Okay. If we go to page 2, we can have a look. What are the consequences if an electrical compliance certificate is not obtained by the seller? If the seller's ever giving you hassles and say, "Well, I'm not going to give you one," you can explain to them that there is a fine, and that fine is 200 Rand a day, and it carries on and on and on until you can just imagine how that can rack up. It also can be a criminal offense. So if someone sells the property, doesn't provide the COC, and a child goes and gets shot and dies, you can almost guarantee that the previous owner who failed to provide the COC will start facing criminal charges due to negligence for not providing the certificate. So it's extremely important that the COC is issued, and obviously in terms of 99.9% of all agreements to sell, it states that the attorney is not allowed to proceed with transfer unless a valid certificate, COC, is provided to the attorney, and the bond attorneys will also ask for it most times. So it's pretty much a standard provided nowadays. Next one, we're going to look at the gas conformity certificate and electric fence certificate. They are also required, and there are different rules around them. But the one thing that's different from the electrical compliance certificate is that there is no 2-year transferable period. So even if it's less than 2 years, when a change of user occurs, then you have to obtain a gas conformity certificate or electrical compliance certificate, electric fence certificate, and that must be provided. What was a problem in the past is that the Act referred to the user must provide the certificate upon change of ownership. Now, there was an argument that the user can either be the seller of the property, or because the purchaser is going to be buying the property become the user, that the purchaser actually needs to provide the gas conformity certificate and or the electrical fence certificate. So for clarity, because the Act has left it quite wide with using the word user, agreements of sale now include the seller must provide at the seller's cost the following documents. But if you are ever utilizing another estate agency's contract, say maybe they're the listing agent, and just check that there is a clause referring to the certificates, because if it's not, and we've seen it before, then you get a funny seller says, no, I'm not the user, and that the purchaser must provide such certificate, and it causes a hassle in everybody's life. Okay. It's important to note that just regarding electric fence certificates, the Act says there must be electric wires, and there must be basically a device that shoots electricity which pulsates on and off. So what some sellers have done, because it's especially around properties with a lot of electric fencing, if the electric fencing is of a bad order and they don't want to repair it and get their certificate, before they sell the fence, they remove the device that pulsates the electricity and says, now it's just wire around my house. It does not form under the the Act regarding the electric fence certificate, and therefore I do not have to provide the certificate. But obviously that must be done prior to the purchaser viewing the property, and it must be told to the purchaser by yourself to say that you will see there's an electric fence. The seller has removed the device that pulsates electricity, and he's not going to be providing an electric fence certificate. And I would for yourself put that in writing. And it happens now and again. The seller tries to be clever. You must just make sure that you protect yourself under these circumstances. You don't want the purchaser saying, well, it looks like an electric fence, I bought it as an electric fence, and now it's going to cost me a fortune to sort out. But the Act does state that it must be wires with basically a pulsating electrical current device. And if you don't have that device, in theory, it's not an electric fence. So some clever fellas have been going around utilizing that loophole. Okay. So what does this all mean to you as a property petitioners? You've got electric certificates, you've got gas conformity certificates, and you've got electric fence certificates. And along the way, it's usually actually the COC that causes the problem, is that the purchaser moves into the property and finds that there is an issue with the certificate, that the system is not of a working order, and becomes very upset and phones up the attorneys and yourself and say, you know, I've got transfer, but all these certificates, or one of these certificates, cannot be valid because there's wires hanging out the ceiling. We had one that was so bad, the electrician had provided a COC, and there were actually wires hanging out the roof. So you obviously knew that this guy either was bribed or didn't even come and look at the property and made a quick buck. So what is the process? And the process is very specific. What the Act basically says, and the electrical board as well, is that if the purchaser goes and makes any changes to the system, himself or herself, the initial electrical compliance certificate is deemed null and void. And then you can't go after the seller as the purchaser or the electrician. So the first thing is to say to the purchaser, do not make any changes to the system, because you'll automatically declare the certificate invalid. Excuse me. So first thing, we tell the purchaser, do not bring an electrician, do not make any changes to the system. Number two, another electrician cannot declare a certificate invalid. Only an inspector from the Department of Health and Safety can declare the certificate invalid. What the purchaser has to basically do is contact the inspector, and the inspector will charge a price, and it's a couple of £1,000, and they'll come and view the property. And if anything is invalid, they will declare the certificate invalid. And this is for all three certificates. I'm just speaking with electrical for sake of easiness in this talk. They'll come and declare the system invalid. Upon the system being declared invalid by the inspector, the seller now is in trouble, because in terms of the agreement of sale, the seller is supposed to provide a valid certificate, and now there is no valid certificate. So the purchaser then can go and proceed against the seller and issue summons to get a new certificate provided. So what is the practical effects of what we were saying here? The practical effect is when there's an issue that arises, tell the purchaser not to do anything. Immediately then get hold of the electrician or the gas installer or the electric fence electrician, and say to them, there seems to be major issues here. Before we go and get an inspector to declare the certificate invalid, come back to the property and fix up all the issues, because once the inspector goes, it can cause huge problems for the say, for example, the electrician. They can get it fines, they can get their license revoked. So you first say to the electrician, rather come back and sort out your issues before we go to the inspector. It's also very important for the electrician to come back, because there's certain grey areas regarding electrical compliance certificates with older buildings and wiring in the wall, and they will accept such electrical compliance certificates or COCs in a lot of the respects where an older house has got old wiring in the walls. But when an inspector comes out, an inspector will declare everything invalid. So something that could have been small, it's a small problem that the electrician could fix, now is a massive issue. And the inspector comes in and says, no, rewiring of the house, which can be 40, 50, 60,000 rand. We had a matter where an electrician wouldn't come back for something small. The inspector came in and was over 80,000 rand rewiring that the electrician had to do himself. The inspector said to him is that you either do it yourself or we're going to take away your license. And the electrician could have come back, fixed up one of the two small things, and would have been fine. But got arrogant and didn't do it. So we contact the electrician and say, rather come back. If the electrician doesn't want to come back, we then the purchaser would go obviously through to the inspector, and they would come and declare it invalid, and then the purchaser would go to the seller and say that this has been declared invalid. The electrician is supposed to come back and fix it, but he's a fly-by-night, and we can't get hold of him, and he's ducked somewhere, which we've seen quite often. And now, in terms of the agreement to sell, you need to provide us with a new electrical compliance certificate, and we've got a report from the inspector, and the house needs to be rewired or something like that. And the seller, who initially paid only 500 Rand to get the COC with a fly-by-night guy, is now, instead of getting someone good and maybe cost him 1,000 Rand or a couple of thousand Rand, is now liable for tens of thousands of Rands. We see it often, that it happens over and over again. I've got a question here. Is it not better for the attorney to choose electrician, electric fence, gas, and pest control services? So this is the same issue for us. We cannot go and say that any of these guys you have to utilize them or choose them. We do have, obviously, the same as you guys, a list of service providers that we have utilized in the past that provide a good service. So we can say to the seller, here's the list of some of the electricians that we've utilized in the past, but we'll make it very clear to them. We do not recommend, we don't guarantee their work, and they've only provided good service beforehand. Why that is so important for you and for us, in terms of the Consumer Protection Act, there's a large range of liability if you basically force or basically give some kind of undertaking that a service provider will do work correctly. They can hold you liable. And I've also seen it where a state agent had recommended a electrician and said, you must use this electrician. Didn't recommend it, said, use this electrician. Something went wrong, and we were before it was then the Statutory Affairs Board saying I was fighting for the guy to make sure they didn't get a fine or lose his license for what they said, pushing an electrician past the seller, and it was a bad electrician. So that's the risk that you run, and the risk that we run as well. So we don't recommend that you obviously say utilize someone. You can just have a list. Okay. Let's go to page 3. Okay. So that's basically the 3 main certificates that you'll find in an offer to purchase, and the ones that are required. Obviously, if there's no gas, you won't need the gas confirming certificate. If there's no electric fence, you won't need the electrical fence certificate. So but it depending on what is there. It says, just to confirm, will the landlord be required to have a new gas certificate every time a new tenant moves in the property? The tenancy is a difficult one, because there is the definition of a user. In theory, if you look at the wording, a user, a tenant can be seen as a new user, and it would be the safest way to get one. But no one's doing it at the moment. You can just imagine the cost of the same. And basically the user, because the owner stays the owner of the property, most interpretations is that the owner of the property is the user, and that certificate is a valid certificate, even though there's a new tenant that comes in. But there is a slight grey area, but 99% of people are not getting new gas certificates with new tenants. Okay. So let's look at an occupancy certificate. Occupancy certificate is coming with something in the past that was only for new buildings, and the bank would sometimes ask for an occupancy certificate, and there was a decision to be made. You would have to provide the occupancy certificate. It was quite an easy thing to get done. But occupancy certificates have become more and more requested by the bank and insurance companies, which I'll quickly go through it regarding the same. So if you look on page 3, you will see that a certificate of occupancy is a document issued by the local municipality confirming that the building has been built within the ambit of the local laws and standards set out in the National Building Regulations and Building Standards Act, and also in terms of the applicable municipal bylaws. Basically what it is when you submit the plans, an occupancy certificate, they'll come and inspect the property, and they will have a look if it basically conforms to various things that have to be confirmed. And you'll see them on page 4. It basically states that the following elements have been adhered to the relevant prescribed codes. So there will be your fire safety code, your structural integrity code, so your building's been built correctly, plumbing requirements, and electrical wiring code. So it basically is a peace of mind for the person moving into the property that it's safe basically to live there, to get your occupancy certificate. In the past, like I said, it was only for new buildings. So the bank would ask for it. It was a building that was newer than 5 years, and they would provide an occupancy certificate. But that's changed now. The banks now are more and more are asking for occupancy certificates for buildings that are older than 5 years. And why that basically is that if a major change, amendment to the property, where something is a structure has been changed in the property, or the use of a room has been changed. So you can, if you've got a room that was meant for a garage, and now it is being changed to be utilized as a bedroom, then in theory you have to get a new occupancy certificate. So any basically changes to the property that are material or structural basically requires an occupation certificate. So not obviously if you go and you do some painting on the wall or minor changes to the property, but in theory, if there's any major amendments to the property, then you have to obtain an occupancy certificate. And you'll see in red, typically new certificates is not required for minor non-structural changes, notwithstanding the same if the renovation affects the building's structure and or use. For example, alterations, removal of load-bearing walls, and or adding additional rooms, an occupancy certificate may be necessary. So then the bank will often ask for one, and it's good for the seller to obtain a new occupancy certificate, and that will be obtained when they submit the new plans. So when you do the change, you'll submit your new plans and you'll get your new occupancy certificate. Alternatively, the occupancy certificate does not lapse. It basically stays valid. So long as there have been no amendments, then you've got your occupancy certificate. Okay. What also very important is if you can explain to the seller that if something goes wrong with inside the property, a fire occurs, a wall falls down, and there isn't an occupancy certificate, then you'll have a situation where the insurance company might repudiate a claim. So it's very, very important that there is a valid occupancy certificate. Without an occupancy certificate, it's illegal to stay in the structure, and you can be evicted and you can obtain fines. So never let anybody move into a property unless there is an occupancy certificate. And like I said, the banks are requesting it more and more. So it's better just to make sure that there is obviously an occupancy certificate. Okay, so we can go down to lower down on page 4. Then we will have a look at who may issue a certificate for a solar system. Now, in the past, a solar system, a lot of the attorneys were stating that you didn't need a electrical compliance certificate for a solar system, because basically, like I said, an electrical compliance certificate is up to the position of a plug. And basically that is incorrect. When you have a solar system requires an electrical compliance certificate, and most of the guys now, the proper companies, they will ensure that you get an electrical compliance certificate when the solar is installed in the property. What you've got to check out, especially for the smaller companies or the fly-by-night guys that you're not 100% sure, is that you get different types of electricians. And you'll see that there are 3 different electricians. You'll get your single-phase electrician, which is an ETSP. You get your installation electrician, an IE, and then you get your master installation electrician. Now, for your compliance certificates, in general, you would use the installation electrician, and the master electrician will provide the electrical compliance certificate, including the certificate for the solar systems. A single-phase electrician can provide a clearance certificate under 2 circumstances. Number one, that it's only a single phase that they're dealing with, so there's not a three-phase. And number two, they have done additional requirements that they've basically done an extra course on providing it, and they get a certificate based on it. So if the person says, well, I am a single phase electrician and here's the certificate, you've got to make sure that he has gone through the extra course. So you will see over here, an ETS may only install a solar system under the general control of an I or ME with a valid wireman's license. So he should be under someone if it in general terms. But an ESME may also not issue a compliance certificate for a solar system unless he has complied with a trade test and completed the required unit standards on inspection, testing, and certificate of a single-phase domestic installation. So he has to do an additional trade test there. Okay. So I've seen there's some questions. Let me just have a look over here. What happens where the property is valued far less and sold? Does it still need occupation certificate, or can both parties accept without occupancy? So if a property is sold, and I'm not quite sure what you mean by far less, if it's half built, let's for example say somebody starts building a property and they sell it, it can be sold, but then it must be sold, and you must incorporate in your agreement to sell that it is sold as a half-built property, is not available for occupancy, and that it has to be finalized, and building plans with occupancy certificate will have to be obtained by the purchaser. Again, if someone's going to occupy a property, they have to have a letter of occupancy to occupy the property, otherwise they're illegal and they will be evicted and get fines. So you cannot occupy a premises unless it has a valid occupancy certificate. But if it's a property that's being built, you can transfer half-built properties. You must just clarify in the agreement to sell that there isn't an occupant certificate. It's not ready for occupation, and it's in the process which the purchaser must obtain. Corinth asks, is a solar certificate also valid for only 2 years? Valid for 2 years. So just remember that electrical compliance certificate is not only valid for 2 years. It can be transferred without doing a new electrical compliance certificate for 2 years. So electrical compliance certificate is valid for basically forever in a way, unless there has been changes to the property. But for transfer purposes, if it's less than 2 years, you don't need to get a new electrical compliance certificate. Even though it's nothing's been changed on the property. In terms of it being valid, that you can transfer, if you can transfer the solar certificate within that 2-year period without getting a new solar certificate, I'm going to have to come back to you on it. It's a very good question. As far as I know, it doesn't. There isn't that extension of the 2 years where you don't have to get a new one. But I'm going to find out for you regarding the same. I'll revert back to everybody on that. The next question is, who's responsible to ensure that the COCs are issued correctly? Okay, so the seller obtains the COCs in terms of the agreement of sale. They believe that they are hiring somebody that is of good standing and that it's working. So that electricity, for example, electrician comes through and says that it's valid. They are liable to ensure that it is valid and produces a certificate. But like I've mentioned before, if it comes out that there's a whole lot of problems inside the property, that electrician the purchaser can send out an inspector and declare that the certificate is invalid. The inspector will first go back to the electrician and say, go fix up your issues. But let's say the electrician doesn't fix up the issues and runs away. Then once the certificate is cleared and valid, then the seller would become liable because the seller has to provide a valid electrical compliance certificate, which has been declared invalid now. So who is liable to ensure that it is? In terms of your agreement of sale, it will be the seller that will have to provide a valid certificate. The electrician will have to go back and fix up in the issues. But if the electrician doesn't go back, it all will keep on falling on the seller to ensure that the valid electrical compliance certificate is produced to the purchaser, and even after it's produced, if it's been declared invalid, and the seller is still liable to go ahead and produce another electrical compliance certificate that's in line with the Act. Okay, let me just see there. There's been a big hype around registering solar systems with the municipality and penalties if not registered. We have a lot of properties with solar and start receiving queries on it. What we're going to do is, with that, we're going to draft up a legal opinion on it. It's a bit of a grey area at the moment. The municipalities want everybody, initially the municipalities wanted everybody to basically sign up, and that they would then give you certain discounts based on you signing up with the municipality. Now, most people around that were of the opinion that the municipalities weren't doing it to be kind and nice, and then their long goal was to get everybody's names that had registered, that had solar systems, so that they could start charging them in the future. So everybody was very worried about it. And it seems like it is definitely moving towards that the municipalities now don't want to have a situation where they don't know who has solar systems and who doesn't, and that it's supposed to be registered with the municipality. So what I'm going to do, Johan, is we'll do a legal opinion on in writing, and basically provide you guys with such opinion if the seller or the purchaser has to register with the municipality, and what penalties they can levy. I'll have that out in the next couple of days. I just want to speak also with a couple of advocates regarding what is the liability, and should we, is it fightable or not to register or not register. So we'll put that in a legal opinion and provide it to the Leapfrog group, because it is coming a big problem now regarding where they were trying to, they tried the carrot approach in the municipality, and now it looks like that they are now going to try using the stick approach. But I will come back to everybody on that. Okay, so Anita says, I have an electrical COC issued on 1 April 2024, where it states that this certificate is valid for 1 year transfer only. The certificate is valid for 1 year. The certificate is not a guarantee. So the new seller cannot use it anymore, even though no changes were made. I've never heard of anything like that before. It's very irregular that electrical compliance certificate is definitely a guarantee that the electrical compliance is in a valid order and everything is safe. That is the whole point of electrical compliance certificate. An electrician cannot waive those rights to say that I'm giving you an electrical compliance certificate, but this is not a guarantee on the work. So it's something that I would, if I was you, the owner, would immediately take that certificate and they go to the Department of Health and Safety. There is a guy called Mark Palmer. Mark Palmer is the inspector, and send it to Mark Palmer and say to him, what does this mean? Why is he limited to a year, and why is he stating there's no guarantee on the work? And let Mark Palmer contact the person and give an opinion on it. But I've never heard of that before. It's always a standard thing that is transferable for 2 years, and it's definitely a guarantee that the electrical compliance is valid and it's safe. Otherwise, there would be no point of obtaining an electrical compliance certificate. Okay, hi Garth. With regard to the stove, if the stove is irreparable, does the seller need to provide a new stove? Because the stove doesn't fall under electrical compliance certificate, we have to look at the footstool clause. So the footstool clause is basically defects that are not easily seen by the naked eye, and the footstool clause cover that. So let me just take a step back and explain to you the difference between the two. You get two types of defects. The one defect is easily seen by the naked eye, and that one is like when you walk into a property and you see there's a crack in the wall. A crack in the wall is, the court has said, buyer beware. It's something that's easily seen by the naked eye. You don't need a professional, and you would the buyer is responsible for that. But there are other defects that are not easily seen by the naked eye, that you require a professional for. So for example, if I sell my car, I know nothing about engines and cars. I will go and sell my car and I'll say that I'm selling it under the footstool clause. And the footstool clause basically covers defects that are not easily seen by the naked eye. And it is a clause for the protection of the seller, not the purchaser, to say that I don't know if this is in a good working order. I'm selling it as is, take it and you cannot claim it back from me. And basically the footstool clause covers that. So regarding the stove, there's always an argument when the purchaser moves in and the stove isn't working. The purchaser is going to say, I want a new stove, it should be in a working order. It doesn't fall under electrical compliance certificate. And the seller is going to go say, listen here, the stove falls under the footstool clause. What is interesting with the footstool clause is that the courts say that it's not all encompassing. If a purchaser can show that the seller knew of the defect and hid the defect with the intent to defraud the purchaser, the court will take away the footstool clause. So what does that mean? We obviously, if the seller has been in the property, he knows that 3 of the rings of the stove is not working. And if he didn't tell everybody about it, it can be argued that he hid the defect with the intent to defraud the purchaser, even though fraud is intent and fraud is difficult to prove. And then the purchaser is going to go to court and they're going to argue that the footstool clause must be taken away and that he wants a new stove in the place. The problem with that, litigation costs a lot of money. So what does the purchaser do? He says, no, I'm not going to go to court and go pay an attorney 30,000 rand to sue the seller to get the footstool clause overturned. I'm going to go after the estate agent, because the estate agent, I can just go to their board and apply pressure, and this often happens. And the estate agent said, well, I did a reasonable inspection with an estate as an estate agent, but I didn't go and turn on all the stoves to see if it was hot or not. And I also asked the seller if there was any defects in the property, and he confirmed in writing that in terms of the report at your mandatory disclosure report that there was no defects. And that's often how it goes. And what I tell every estate agent is that you always got to cover yourself. The mandatory disclosure form is a protection for yourself because it proves that you asked the seller if there were any defects in the property. And if the seller said there's no defects in the stove, you've already asked if there's an issue. And then you must do obviously a reasonable inspection. So that's always an issue with a stove. It often ends up in litigation and fighting. We've got a problem-solving department. We sort it out ourselves, but it's always a question for the purchaser saying, obviously the seller knew of the defect and hid the defect. The intent to fraud, those rings weren't working. I want a new stove. It doesn't fall under the footstool clause. And then there's different fights over it. Sometimes the seller says, well, I wasn't staying in the property for the last 2 years. I rented it out. So I obviously did not know that the stove wasn't working. And so I didn't have a intent to defraud you. So it falls under the footstool clause. And you can see that there can be so many gray areas with it. The best thing to do is to ask the seller and put in your mandatory disclosure form if there's issues with the stove. And if you do have the time, is to, if it looks like an older stove, see if you can put on the stove and make sure all the rings are working, because it's something that definitely does pop up. If it find out that only one of the 4 rings are working, then include that into your offer to purchase to say that only one of the 4 rings are working, so that you protect yourself from any litigation. But that's the issue with stoves and the footstool clause. Let me have a look here. So installing new lights, we change to the COC. If it's a bulb, no. But if you're putting new lights, once you basically are putting any amendments or changes to the electrical wiring, and you're connecting something new, in theory, yes, you would have to get a new COC because you are doing an amendment to it. The seller is planning to list the property and disclose the stove is not in a working order. Yes, so if the seller is perfect, if they disclose that the stove is not in a working order, then you can record it in the agreement to sell, and then the purchaser can just accept it or not accept it when they sign the offer to purchase. As long as it's recorded, that's fine. So that's why it's very important that you record everything in writing to protect yourselves. But like I said, everything's up to the plug for the electrical compliance certificate. Everything else, like a stove or appliances, they do not fall under the electrical compliance certificate. So that will fall under the clauses regarding the patent and latent defects, as well as the Fuster's clause, and also under your liability as a property petitioner to do a reasonable inspection of the property. So always remember, and as I always say to all of you, protect yourself, because when things go wrong, no one wants to spend money on attorneys. They're going to run to the board and say, you should have checked the stove, you should have checked this, or you should have checked that. I can't go after the electrician, it's too expensive to go after the seller, and they run to the board. So always do your 2 points that you always have to do. You have to ask the seller if there's any issues on the property, record it with your mandatory disclosure form, which shows that you have asked. And number 2, do a reasonable inspection in terms of a property petitioner. If we've done those 2 elements, when we go to the board, it's an easy game for us. We show that you've done both sides of that, and we walk away with no fine or with or losing of your license. But if you missed one of those 2 elements, then you're in a lot of trouble. So just make sure that you do those 2 elements, because as you can see, when we talk about these things, there are so many nuances and gray areas regarding court cases, Fuster's clauses. Is it a patent or latent defect? Did the stove break? Was it already broken when the agreement was signed, or did it break between when the agreement of sale was signed and when it was registered? Those are all things that can be argued, and that's the problem with the law. You'll go and you'll look at all the law cases, and you'll have 2 in the High Court, 2 advocates, usually 2 senior advocates, who both believe they're right. They both argued, and one of them was found to be wrong. So it's like water, it keeps on moving, and there's so many little nuances and differences in each of the matters. So again, my last thing I'm going to say to you guys: this is your profession. Look after yourselves. Do the 2 things that you have to do, and if there's an issue with it, give me a call. It's a scenario where we will either provide you the information. If we don't have it, we'll find out and get back to you. Okay, everyone, it seems like that is the final details, the final questions. Thanks for Johan for putting Mark Palmer's there. It's